Happy Friday, everybody. Today is October 17th, 2025, and this is your Friday planning video. Now, here's a quick question I ask clients all the time. If something happened to you tomorrow, would your loved ones know how to access your accounts? It's not a fun question. None of us like to picture incapacity or death, but here's the truth. Failing to plan for these moments can leave your family locked out of the very resources they need most. I've seen it happen. A spouse unable to pay bills because an account was only in the other partner's name, adult children unable to provide care for a parent because no one had legal access to the funds, or even worse, assets tied up in probate for months while medical bills and daily expenses pile up. That's why today's video is about something simple but vital. Beneficiary designations, proper account titling, and digital access. Done right, these steps ensure that the right people can step in quickly when life takes a turn. Before I get too far here, I'm not a lawyer, and most of this, if not all of this, gets into some pretty complex planning on the legal and tax side. This is where your whole team plays a part. We can bring in your tax and legal advisors and make sure the plan is in line with what you want to do. Why does this matter? Most people think estate planning is all about wills and trusts. And yes, those are important, but here's the catch. Many assets, retirement accounts, life insurance policies, and even bank and brokerage accounts, they don't pass through your will, or sometimes they don't. They pass by beneficiary designation or by how the account is titled, which means you could spend thousands on a beautiful estate plan. But if your beneficiary forms, account titles, or digital access aren't updated, your money will not go where you intended it to. And here's the kicker. Beneficiaries designations, they will override your will. If your will says one thing, but your 401k form says another, the 401k form wins. Here's the two big risks. Let's break it down into two scenarios. There's death, unfortunately. If you pass away, who gets your money? Without proper designation, it might get stuck in probate, delayed for months, eaten away by legal fees. Incapacity, if you're alive but unable to manage your finances, say from illness, stroke, or dementia, who can access funds to provide care? Without proper titling, powers of attorney, or store digital access, your loved ones may be powerless, even as bills mount. Both scenarios are preventable, but only if we plan ahead. Let's start with beneficiary designations. Retirement accounts, that's 401ks, 403bs, IRAs, Roth IRAs. Life insurance policies, those can be simple, but only if the forms are up to date. And annuities and HSAs, these are easy to overlook, but they do require designations also. Each typically allows primary beneficiaries who get the money first and contingent beneficiaries who get the money if the primary is gone. Small oversights here can create big problems. Here's some common beneficiary mistakes. None of them are absolute, and these are general outcomes. You can confirm with your legal advisor, or better yet, we'll stay ahead of it and get everything properly planned. Mistake number one, no beneficiary listed at all. Now, the account may default to your estate and probably end up in probate. You've heard this from me every few weeks. So as we keep working with you on it, you'll hear from me more. Another common one is outdated beneficiaries. You set your plan, you do all of the paperwork, and life continues. Just as the Greek philosopher once said, the only constant in life is change. Divorce, remarriage, children or grandchildren not listed. Yes, I've seen ex-spouses inherit six-figure accounts. This is why it is not a fix it and forget it part of your plan. One that is so common also is another one, minor children named. Now, in this case, courts must appoint a guardian. It's slow and it's costly. If this is in your plan, let's discuss it, with all the important parties to be sure it's handled well and quickly. Another issue can be special needs children named directly. One of the biggest parts of this is that it may jeopardize government benefits. Better to route that to a special needs trust. Again, this is a key part of what I work with some of my legal teams with. It can be done right, but often it is not. Again, major legal issue, and should speak with your legal advisor on that. As I mentioned, one error is that your beneficiaries conflict with your estate plan. Remember, if the will and the beneficiary forms disagree, these assets, the forms win. Let's touch on account titling. The other half of the equation is beneficiaries only cover certain accounts. Titles matter also. Joint tenancy with rights of survivorship. That surviving owner takes over automatically. The tenants in common. Each owner's share goes through their own estate. TOD, transfer on death, or POD, payable on death. This is simple add-ons for bank and brokerage accounts to bypass probate. And trust ownership. Retitling into trust can provide seamless management both during incapacity and after death. There's a lot to discuss with each of these, so let's review it with your legal advisor. Unfortunately, coming up more and more is the incapacity problem. Imagine that, God forbid, you suffer a stroke or develop dementia. You're alive, but you can't manage your accounts. If accounts are only in your name, your family can't legally touch them. Without a trust or a durable power of attorney, they may need a court order. That means legal fees, delays, and stress at the exact moment when care costs are rising. Again, let's talk to the legal advisor, but here are some ideas for solutions. That durable power of attorney that authorizes a trusted person to act. Trusts. A successor trustee can immediately manage the accounts. Joint accounts, useful in some cases, but should be used carefully. And before we go, the overlooked piece, your digital access. Now let's add a modern wrinkle. Welcome to 2025. Even if accounts are titled correctly and beneficiaries are set, your family may still be locked out digitally. Think about it. Bank accounts, brokerage portals, retirement accounts, credit cards, online bill pay for utilities, mortgages, insurance, even digital wallets, PayPal, Venmo. Without usernames, passwords, two-factor authentication codes, access can grind to a halt. This is why digital estate planning has become so essential. Some ideas on how to plan for that. Password managers. Tools that do this can store all the logins in one place. You can name an emergency contact, or you can share that vault access if you need to. Written lists. Now you have to store those safely, of course, but that's old school, but effective if you keep it in a safe or a fireproof box. The risk is security, so handle it with care. Also, don't put it in a safe where only you have the combination. Communicate. Let trusted heirs know where this information lives. Having it hidden in your head or on a sticky note on the fridge isn't a good plan. Here's the bottom line. Without digital access, even properly titled accounts can feel like padlocked vaults. Let's give some action ideas. Here's some practical steps that you can take now. Review your beneficiaries annually. Make sure that both primary and contingent names are correct. Coordinate with your estate documents. Now, this is a big one. No contradictions between your wills and your forms. We've talked about that before. And your TOD and POD designations. That's a simple way to bypass probate. Consider a trust. Now, again, it's not for everybody. For continuity and management flexibility, but it might work for you. And set up powers of attorneys to avoid court battles and incapacity. Organize your digital access. Now, again, we've talked about this. Use a password manager, document your instructions, and think about sharing exactly how that works. A few real life stories. In 3 decades and counting, I've seen a lot of these. The locked IRA. A widow died, leaving her deceased husband as the IRA beneficiary. No contingent named. The result? Probate and months of delay. The Alzheimer's struggle. Now, this one we see way too much of course. Accounts in one name only, no powers of attorney. The wife spent thousands in court just to pay for the care. The password problem. An adult daughter couldn't access her father's accounts because he never shared logins. Bills piled up while the bank processed paperwork. Thank goodness most of the time we have the following. The smooth path. That's updated beneficiaries, joint accounts titled correctly, a trust in place, and stored passwords and a manager with shared access. When the loved one passed, the transition was seamless. His family could focus on healing, not fighting systems. Now remember, beneficiaries equal death planning, titling and POAs and powers of attorney, they equal incapacity planning, and digital storage is just practical access. Miss any one of these, and your loved ones could face locked doors. When you've aligned your beneficiaries, titled your accounts properly, and organized digital access, you're not just creating a financial plan, you're creating clarity. Clarity for your spouse, your kids, and anyone who might need to step in. Instead of wasting energy on court filings and guesswork, they can use your money for what it was always meant for, caring for you, and later carrying on your legacy. So let me ask you again. If something happened tomorrow, would your loved ones know how to access your accounts? If not, this is your call to action. Update your beneficiaries, fix account titles, put powers of attorneys in place, and yes, make sure your digital keys are organized and stored securely. Because the last gift you want to leave your family is a maze. The better gift, a clear map. This video wasn't that uplifting. Sorry, it wasn't that big planning video that uplifts you. Sorry, but there's a little work now you can do that can save us a lot later. Have a great weekend and keep planning.